normally I would say that that's going to be permitted provided the government pays for it. As the Americans say, no takings without compensation. The government can take your property, but they have to pay you compensation. I'm talking about land here. Whereas in private law context, the right to property means other private individuals just can't take your property. They're not supposed to be able to do that, subject to the law of adverse possession. So the right to property, I think, means different things in a public and private context. And so too freedom. I've talked about liberty. Liberty is clearly very important in a public context, the freedom to act as one wishes to do, whereas freedom in the context of freedom of contract is actually a rather different idea. It's about the freedom to make contracts, the freedom to enter into markets, the right to work, and other aspects of freedom of contract, which is a much more positive conception of freedom. It's the right to do things rather than the right to be left alone. And thirdly, and perhaps crucially, in a private law context, both parties will have fundamental rights, invariably, whereas in a public law context, only this individual citizen has rights, not the state. So that the application of fundamental rights in a private law context is always a balance between the rights of two private individuals, whereas in a public law context, there is only the private individual has the rights. So I think that takes me to say that the requirement of alignment, the idea that private law should be aligned with the fundamental rights found in the Constitution, is potentially disruptive. That the common values, although vaguely there, are not going to stop the application of fundamental rights being found to be quite subversive sometimes of the existing private law doctrine. And the process of alignment means that in every case, potentially, a court must consider whether or not the human rights aspects, the fundamental rights aspect, require a slightly different result in private law. So it's a whole new dimension of legal reasoning. When you've finished the private law analysis, you've done all your law of contract or all your law of tort, you then have to say, but is this result compatible with the Constitution? Usually it will be, but sometimes it can be argued that it won't. So my preferred analysis of the relationship between public and private law is found in this this other slide, my brooding omnipresent slide, which says that fundamental rights are like sun. They're like the sunshine. They shine down on both public law and private law. Sometimes they're quite dazzling. You sometimes need some glasses when you're studying the law with this bright sunshine. But whether it's public law or private law, the fundamental rights put everything into very sharp relief. And you have to always think about that dimension in legal reasoning. So it's always present in every aspect of the law. So they somehow are, the fundamental rights float above the planet of the legal system. Well, I've tried to explain to you what I mean by constitutionalization of private law, and I've tried to persuade you that it means something and that it could lead to significant changes in the law if you start applying fundamental rights to contract and tort disputes or property disputes. It could do that. But I now want to persuade you that the changes that it will require will not be great, but then I'm going to argue that although not great, they are potentially beneficial. The reason that's usually given for saying that the changes that will happen as a result of this process of constitutionalization of private law, the reason that's usually given for saying the changes will not be great is an argument that there will only be indirect effect or indirect horizontal effect. And I apologize for that terrible jargon. And I want to explain that this is false news, big time. That, what indirect effect says is this, that in say a contract law case, what the judges will do is apply ordinary contract law, but then interpret that law in a way so that it's compatible with fundamental rights. What they will not do is say to people that as well as your contract law rights, you've also got fundamental rights from the Constitution, which we will apply to your contractual dispute. In other words, the only way that fundamental rights can affect the rights and duties of the parties to a contract or in a claim in tort or a property dispute, the only way that the fundamental rights can affect the dispute is via or through an interpretation of the existing private law. Or to put the point another way, that the fundamental rights cannot create new causes of action. They can't create anything new, they can merely tweak existing law. So I'm going to show you why that's untrue, that when the courts say that what they're doing is giving indirect effect to fundamental rights in private law, what they're in fact doing, in my view, is creating new causes of action, new rules, giving people new rights. That doesn't worry me, that's a good thing. All I'm saying is that this indirect effect is just deeply confusing, and it's and we need to get rid of that misleading doctrine, I think. I thought by the time we got here you'd be fed up looking at me, and you might like to look at Naomi Campbell's very nice smile. So here's a famous case in English law, tort law case. It concerned the supermodel. I don't know what makes her super, nice smile though. Supermodel who was pictured by a journalist leaving a drugs rehabilitation clinic. This was embarrassing to her since she claimed that she didn't have a drugs problem, though she clearly did. And she wanted the picture, she wanted an injunction against the picture being shown, essentially, by MGN, which is Mirror Group newspapers. So there's a dispute between the newspaper that wants to show that she lied, and she says, well, this is my private life. You know, I was going to see the doctor. Basically, I don't think the journalist should follow me around taking pictures of me when I'm doing that. So she tries to bring a claim to stop publication of the picture, but she's got a problem, which is she has no legal rights in tort. There's no law in English law of right to privacy. There's no right to stop newspapers taking pictures of you as you walk down the street. So, nevertheless, with presumably some very expensive lawyers, she brings a case, and it reaches, I think it would have been the House of Lords in those days, the Supreme Court today. And the Supreme Court concludes that indeed she does have a legal right. They say that what they're doing is developing the English law of tort, a tort about breach of confidence, which clearly has nothing to do with people taking pictures of other people in the street. They are expanding it. And then when they come to define the tort, it becomes clear that it's just a matter of fundamental rights. So here's a quote from Lady Hale. She says, so the bottom line, the position we've reached, is that the exercise of balancing Article 8 and Article 10, Article 8, the right to privacy, Article 10, the freedom of the press, the balance between Campbell and MGN, may begin when the person publishing the information, the newspaper, knows or ought to know that there's a reasonable expectation that the information in question will be kept confidential. So my point about this case is this, that what's happening here is the court is saying, well, we're developing the existing law of tort, but in fact the tort they've created is a tort that involves balancing the fundamental rights of the newspaper against the individual's privacy, and we don't need to know the results. It's quite complicated, the result, because it's a 3-2 majority. They take slightly different positions, but they're all agreed that there's a new tort, and that the tort is based upon fundamental rights. This seems to be a good result, an improvement in the law engineered by the fundamental rights, but this is not indirect effect. It's not some interpretation of the existing law, it's the creation of a new tort.